Well, thank you all very much. As Dean of the George Washington Law School, usually when I walk into a room, I have to earn the applause first. So this is really very great. Ladies and gentlemen, it is indeed a pleasure for me to welcome you to this program that the George Washington University Law School is jointly sponsoring with the Alliance for Justice. I have been Dean of the Law School now for 8 months, 20 days, 14 hours, and 15 minutes. And I've got to tell you, one of the reasons that I came to this wonderful law school is not only because it is a law school that fosters a great sense of community, which we need in American legal education today to train better professionals, but also we want to really educate individuals on the salience of law throughout our society. And certainly the program that we have today does this. We have a very special guest whom all of you are very much familiar with. He has been a hero of mine for a very, very long time. And I am very proud to do this with the Alliance for Justice. I will tell you that there have been so many commentaries made about American legal education, whether it's worth it, whether the value is there. One of the things that I have said, both as Dean of this law school and now the current president of the Association of American Law Schools, is that there is no other profession that provides the leadership for a modern democracy than legal education. And it's important for law schools to extend themselves to communities to make sure that they're educated on some of the cutting-edge issues of today. Certainly our program today does that. We are proud to have you here with us today, and we're proud to do this with the Alliance for Justice. And without further ado, it is my pleasure to pass the baton over to Nan Aaron, who is president of the Alliance for Justice.
Thank you, Dean Moran, and many thanks for the GW Law School for co-hosting this wonderful event. You and your staff have been terrific to work with, and we're grateful for the partnership that has created what will be a memorable hour for all of us today. For those of you who are new to Alliance for Justice, we are a membership association of over 100 organizations. Our groups are varied, representing workers, consumers, women and civil rights, as well as environmental and immigrant activists. Our justice program plays a central role in both securing access to justice for underserved Americans and promoting good, progressive judges committed to equal justice. Our Bolder Advocacy Initiative coaches nonprofits and foundations to become smarter and more confident in their advocacy. We're proud of our role not only as advocates, but as the preeminent source of data and information about the judicial selection process. I encourage all of you to visit our website at afj.org and check out our new judicial selection dashboards, our online tools for anyone who wants to keep up-to-date current with the confirmation of judges. Our work at Alliance for Justice is premised on the principle that courts matter. So it isn't a surprise that we spend a lot of time assessing and commenting on the Supreme Court and the justices who sit on it, the cases it takes, the precedents it sets, and the legal and political ramifications of its decisions make it one of the most influential institutions affecting people's lives. Our message that courts matter is truer now than ever, especially given the overtly political and ideological nature of the high-stakes cases being argued in the Supreme Court. So I can't think of a better moment to hear from someone who's been in the crucible himself and who understands at a profound level what's at stake in this and future courts. John Paul Stevens has been aptly called a national treasure. He's exactly what we hope Supreme Court justices will be: elegant, brilliant, curious, gracious, cordial, gutsy, open-minded. He was appointed to the court by President Ford in 1975. By the time he retired in 2010, Justice Stevens had been a participant in some of the most important and hard-fought cases in Supreme Court history, and left as the third longest-serving justice ever. He has a perspective on the law and the role of the court in American life that few have. Although he's no longer hearing cases, his service to the nation continues as author of 6 amendments, How and Why We Should Change the Constitution. His book, which deals with issues as diverse as the structural problems affecting our democracy, to gun rights, to the death penalty, achieves the important goal of provoking thought and conversation about central issues in our constitutional system. You don't have to agree with him to appreciate the intellectual rigor of his arguments, his courage to confront tough problems, and his respectful and open-minded approach to issues in which there are many points of view. Those are the same characteristics, by the way, with which his service on the court was judged by his peers and his admirers from all points of the ideological spectrum. We're deeply honored to have Justice Stevens with us today to talk about today's court, his ideas for reform, and the role the court plays and should play in national life. At the same time, we're thrilled to have 2 of the most interesting journalists in America guiding today's conversation. Dahlia Lithwick is senior editor at Slate, where she puts her English degree from Yale and her law degree from Stanford to work, writing her massively popular Supreme Court dispatches. Dahlia does something that very few people writing today can do. She makes complex issues of law understandable and interesting, and most importantly, relevant to her readers' lives. The court comes alive in her columns, and in today's scary legal environment where everyone needs to pay attention, that's a service that cannot be underestimated. Jonathan Capehart is a member of the editorial board at the Washington Post and writes for the paper's post-partisan blog on political and social issues. Jonathan was a key contributor to the New York Daily News editorial team that won a Pulitzer Prize for a series on Harlem's Apollo Theater. You've also seen him on MSNBC, where he's hosted Hardball and shown he can hold his own and then some with the best of us. We're pleased that Jonathan will bring his unique perspective and Pulitzer Prize-winning journalistic skills to our conversation. On behalf of the Board of Alliance for Justice, our chair, Ken Grossinger, who is sitting with us today, we welcome you, and please let's give our speakers a hearty round of applause.
Thank you all for being here. Justice Stevens, an honor to meet you and to have you here. We're going to dive right into our questions. And the first one is about litmus tests. Litmus tests. 2 of the Democratic candidates for president, including Hillary Clinton, recently said they have a litmus test for potential Supreme Court nominees and that any candidate must give his or her assurance to overturn Citizens United. What's your reaction to the use of case-specific litmus tests to screen Supreme Court candidates?
Oh, this is a surprise question for me. I did not know that the candidate who I thought probably has the strongest argument is that she would be the first woman president. She wants overrule a particular case. I do think the case was incorrectly decided, as I think you know, but I'm not really sure that that's wise either for the court or for a presidential candidate to make a litmus test on one particular decision like that. But I haven't had time to think this through because I'm surprised at her statement and I'm surprised about the question. But the answer is if I were running for president, I don't think I would make such a litmus test.
Go ahead, do you want to?
I should say, even though I think the case ought to be overruled, I don't, there's no doubt about that. I took a few pages to make that point a few years ago.
Do you want to reflect a little bit on why the public is so angry about Citizens United? It seems like a case that, at one level is quite abstract and it is about, campaign contributions, and yet it's the thing that I think really enrages people. What is it about Citizens United that resonates with something that people are angry about?
Well, that's another question I hadn't thought about.
I'm so sorry.
But I do think that Byron White really hit the nail on the head in his dissent in Buckley when he pointed out the importance of public confidence in the electoral process. And I do think it's unfortunate that the opinion and the later cases that have followed it give the impression that people with a lot of money have more influence than the average citizen. And the basic principle of elections and democracy is one person, one vote, not a large number of votes for one person with a lot of money.
So there's one thing that I've find most fascinating about you is that when you were on the Seventh Circuit Court of Appeals, you were considered a moderately conservative judge. And then there was a statistical study done in 2003, I believe, that showed you were the most liberal member of the Supreme Court. How did that happen? Did you change?
No, I really think some of the writing about my work on the Seventh Circuit is not entirely accurate. In fact, that particular question, and it reminds me of a question I received from Senator Kennedy during my confirmation hearings. And he asked me basically how the people are going to have any confidence in your ability to represent the common man and so forth, or the submerged classes, I guess he was talking about. And my response was that the two letters I had received supporting my nomination were both from inmates at Joliet. They might not have been the most persuasive advocates for my position, but they did indicate that I had written some opinions that some people who were members of the submerged classes agreed with. Yeah.
So, okay, let me ask it a different way. Why do you think you were, by the analysis of your voting record on the Supreme Court, why do you think you were deemed the most liberal? Did you change, or did the court change, or did the country change?
Well, I don't know if the country's changed, but the court certainly has. There's no doubt about that. And I think I said when I was an active justice on more than one occasion that after, I forget this point, I guess after Nixon became president, every appointment to the court was more conservative than his or her predecessor. And I think that's true, and it's a trend that is pretty much hasn't been uninterrupted. Of course, there are periods, members of the court like Justice Breyer and Justice Ginsburg and Justice Kagan who are not in that trend. But for a period, it was true that membership of the court was in a constant direction of more conservative than otherwise.
Mm-hmm. And more conservative than the country, would you say?
Well, it depends on what part of the country you're talking about. And not more conservative than the South, for example, mm-hmm. But I'm not sure I have an answer to that.
Justice Stevens, one thing that I've noticed in covering the court is the extent to which oral argument has really become sometimes very bombastic and very ideological. And I'm thinking specifically the last week of this term, they argued a lethal injection case. And, on the one hand, you had the conservative justices saying, oh, this is because, capital punishment abolitionists have made it impossible to get effective drugs. On the other side, you had the liberal wing saying, people are being burned alive. And it was very dramatic language and not what you're used to, I think, from oral argument. And I wanted to know if you think that oral argument has changed, if it's become more ideological, if people are talking in sound bites.
I don't know if it's more ideological, but they use the term a hot bench. The bench has gotten warmer during the last few years. I think that's true, but I don't think it's necessarily an undesirable development, because the more questioning takes place in the courtroom, the more the public gets an insight in the way certain individuals are thinking. And I do think that the interchange among the justices does sometimes help in the decisional process. They may persuade one another or persuade particularly one another on the issues.
So it's that the tone that's sort of very, very aggressive, and sometimes it almost seems like they're looking for a laugh or they're looking for reaction. That's not crossing some line in your view. You think that's important?
Well, I haven't attended any of the arguments, so I can't really comment on it. But I do think that the fact that people interpret some of the questions as you had a phrase that you used to say.
I think I said aggressive and ideological.
Oh, as ideological. I think that's unfortunate, and I think actually that's one reason why it's wise for them not to televise the arguments, because I think it would have it would enhance that tendency to make it more of a show or something like that. And but I think on the whole, vigorous and questioning is good for the process, and it's good that they speak up. Are not afraid to ask questions that identify their point of view and that sort of thing.
Well, Justice Stevens, you anticipated the question I was going to ask. Dahlia mentioned sound bites in her question. You talked about the public having an insight into where the justices are. And I was going to ask you, well, tell me your opinion about televising Supreme Court hearings. And you just said no. But because of you think it would push the justices into more ideological arguments?
The reason is that I think that televising might have an adverse impact on the deliberative process. I think the oral argument is an important part of the decisional process, and it's very often when you introduce television into an area, a medium that it hasn't been before, the medium may change in ways you don't anticipate. And if going to a football game, you may wonder why their players are standing around for a minute or two in the middle of the game, and there's a television commercial on that they have to, and that changed the football game. I think it has changed some of the congressional hearings where they televise them, and I don't think the change is always for the better. I believe firmly in the value of having the public learn more about an institution, but you should be sure it's not going to have an adverse effect on the institution itself.
Is there a concern that one of the justices might be a bit of a camera hog?
I think there's a risk that any one of 9 might become. Because when you're up there, if you think of something that you really have, you think of very, very clever remark, temptation is to share it with the world, you know.
We have that problem on television all the time. that oh God, I can't believe I didn't think before I spoke. So I think it's not uncommon. But
on the other, there is a good argument in favor of television, and that is that the public in general would have a higher respect for the court than they do without knowing, because they will see that the justices are well prepared. They know what they're talking about, whether you agree with them or disagree them. They are intelligent, hardworking people, and I think that would come across.
Does it matter to this calculus that, for instance, the Canadian Supreme Court has been doing it for decades, or that the Supreme Court and the British Supreme Court has been televising their proceedings, and most states have some form of televised hearings? I mean, it seems as though the fear that everybody's going to act up hasn't been manifest in the courts that have done it.
That may be true, but I also I think that you would say, just from your observation of the court, that this court is not exactly like all the rest of them.
I think I would agree.
Justice Stevens, is there a decision you most regret?
Well, I think probably Citizens United is one of the decisions that I made that I most regret. Nothing comes to mind, I must say. I should say, though, that Nina Totenberg, who was going to be on this program, interviewed me some time, 3 or 4 years ago, and asked me that question. And I remember telling her that I made an error in my vote in Jurek against Texas. And the reason I was an error, I didn't listen to my law clerk, who advised me the other way, because that case actually presented a question of whether the Texas death penalty statute should have been treated as a mandatory statute, as a death penalty statute. And if you read one of the instructions that they had to give the jury, and a certain answer really required the death penalty. And I voted to uphold the Texas statute, and I was wrong. And my former law clerk, who now teaches at Virginia Law School, George Rutherglen, told me I was wrong ahead of time. And I did not follow his advice, and I went along with the decision. But Nina asked me the same question 2 or 3 years ago, and I tried to give the same answer I've given now, describing the Texas case. And she interpreted my answer as having said I regretted my vote in all 3 of the death cases that were decided at the same time. And she's been quoted for that statement in other places. And she expanded on my answer beyond what I actually said. And I thought I'd be able to tell her today what, and she didn't show up.
But this is being taped.
It's being taped, and
so
I'm going to also
soon
send
enough.
her an email. I will send her an email as soon as we're done and let her know she needs to watch.
By the way, she's a good reporter and one of my favorite people, so don't
She is fantastic. So you mentioned the death penalty, and you wrote about it in 6 Amendments, and I wonder if you think, I've been hearing, particularly now around the Boston bombing trial and the renewed conversation about the death penalty, I keep hearing people say, it's on its way out, where we've peaked in terms of national support for the death penalty, and there's all these DNA exonerations, and people are just pretty much weary of it. Do you have a sense that as a country we're moving towards abolition?
Oh, yes, I think we definitely are. And one of the things that interested me in reading about the Boston trial, I don't know if these figures are accurate or not, but there was one story I think I read that said that the general public in the Boston area, about 75% against the death penalty. But of course, that illustrates one of the flaws in the procedures that are involved in death cases. The death-qualified jury is not representative of the community. And that one statistic really demonstrates it, because the people who, most of the 75% could be challenged for cause and do not make it. And that's one reason that the death penalty is much more unfair than we thought it was at the time back when we decided the 3 cases and followed after Furman. And I had expected that the procedures would be more protective of the defendants in death cases than in ordinary criminal cases. And in several respects, and I think I make this point in the book, they in fact are more pro-prosecution. And so the risk of error is larger in death cases than it is in other cases. And that certainly can't be right. Mm-hmm. It certainly can't be right. And so that I do think that, I also think the public, more and more members of the public, are conscious of the fact that it's really not necessary, because life imprisonment without parole protects the public at least as well as execution does. And so the justification for the death penalty is diminished. And I think if you make a cost-benefit analysis, just on the cost of the trials and all the rest, it's a terrible waste of society's resources to have these capital trials that go on for so long and produce an awful lot of unfortunate results.
Mm-hmm. How much time do we have in our 5 minutes? Okay, I'm going to make sure I have enough time to ask this question, Justice.
Nan says 10. So.
Oh, 10? Oh, I might get to ask my second to last question. But the question I have for you, Justice, as we all know, you stepped down from the bench in 2010. And I'm wondering what role should and does politics play in the decision as to when and whether to step down from the Supreme Court?
Well, I suppose it varies from person to person and different times. I stepped down because it's been publicized elsewhere, but during the oral announcement of my dissent in Citizens United, I had difficulty articulating what I said, and I stumbled during the speech. And when I got off the bench that day, I said to myself, so there's something that's wrong. You're not as articulate as you used to be, and you better take advantage of your knowledge. And so I decided then that I would retire as an active justice, and so my decision was not affected by politics one way or another. But I know others. I think when Byron White retired, he did want to have a Democratic president appoint his successor. He was very active in the Kennedy campaign. It was a matter of importance to him. And I disagree with Byron on a lot of issues, but I'm also he was one of my closest friends on the court. And he did think it appropriate to consider the political ramifications of your decision. Certainly it's an appropriate consideration, and my guess is that there are members of the court now who would definitely stay on rather than retire if they think the change in their seat might affect the composition of the court. I don't know what my answer is to your question.
You gave an answer. I got an answer.
I want to ask you about, you've thought so deeply about the role of the Chief Justice, and you've written about it, and you've known 5 chiefs and written about that. Can you talk a little bit about John Roberts, how he's inhabited the role of chief? I think in our heads, we all think it's just a 9th justice, and maybe they assign opinions and decide some things. But they make a big difference, and I wonder if you could speak to John Roberts' role as chief.
Well, I think he's a very good chief, to be honest with you. I don't agree with a number of his opinions, but I do think in terms of the duties of the chief, other than voting on cases, in which case he has exactly the same authority and power as any other justice. But in terms of making the court be an effective public institution, I think he's an excellent chief. I think he's an excellent Chief Justice. I think he's a good representative when he meets foreign justices and things like that. He's a very likable person, and I think he's a good Chief Justice. I think he's an excellent Chief Justice.
Okay.
I want to ask you about the perception of the court and there have been some polls recently, and correct me if I'm wrong, Dahlia, that the American people are viewing the court more than in the past as being political. So I'm wondering if you think it's a good thing or a bad thing that more and more American people are viewing the court as just another political institution, another political branch in our government.
Well, I think it's a bad thing. I really, and I've thought about this recently, I think what I wrote in Bush against Gore was absolutely right. I think that that particular decision diminished the public's perception of the impartiality of judges generally, and I think that decision was every bit as harmful as I suggested it would be in that dissent. So I think it's unfortunate that courts appear to be perceived in that way, when in fact they are not necessarily as biased or political animals as people think they are. But I think the perception of political judicial decision-making is really unfortunate.
And Justice Stevens, does the confirmation process contribute to that? I mean, it seems to me, we've heard it said, we'll never get another Scalia confirmed, we'll never get another Ginsburg confirmed because the confirmation process has. So is the politicization of the court, or the perceived politicization of the court, is that a function of the way the press does it, or is that a function of a confirmation process that has really changed in your lifetime, I think?
Well, I think it's changed since the Bork hearings, and I think it's a change not for the better. I think that the change is probably responsible for the fact that the members of the court tend to be more homogeneous now than they were when I joined the court. They're from the Northeast, the Northeastern law schools, and the process tends to I'm sure makes I haven't participated in any of these decisions, but I'm sure it makes the president more conscious of the problem of getting confirmed, which has an impact on the actual makeup of the court itself. And I do think it's unfortunate, but on the other hand, I don't think there's a single member of the court who's not very well qualified. They're extremely good lawyers and intelligent people, and there's sort of pluses and minuses in that.
Can I ask, I know we're about to go to
1 minute.
1 minute. So here's the question I was hoping I'd get to ask you before we turn it over to the audience, and that is, what advice would you give? Because there are a few young people out here who I'm sure have visions of sitting on the Supreme Court. So what advice would you give an aspiring Supreme Court justice that you wish you would have been given when you were their age?
That's very interesting. I don't, it's kind of old-fashioned, I guess, but study hard, work hard. and the law really is a very, very marvelous profession. And I don't think I'd give you any different advice than I would have given before I was a judge. Yeah.
Great.
May I ask one last question? I know this is mean. But you are always reading some amazing book and often reviewing it or talking about it. What are you reading? What have you read in the last few months that all of these students should be reading, or that I should be reading?
Well, I just looked this morning again. I'd read it some time ago, a biography of Elbert Tuttle that was written by a professor at the University of Georgia. I can't remember her name as I sit here. But it's a wonderful story of a very gifted judge who's not nearly appreciated as much as he should be. And so that's one book. I put it on your reading list. He was not only a veteran of World War II, but also World War I. And he grew up in Hawaii and practiced law in Atlanta eventually, and became a very, very effective judge. Okay,
I'm going to take that as my summer reading list, and write to Nina. I've got a lot of homework. So we are going to take questions for Justice Stevens with the strong and urgent reminder that you ask it in the form of a question and that it be brief. And we're also going to ask you to move to the mic in the middle of the room so as soon as we've acknowledged you, so that we're not passing mics around. So if you have a question for Justice Stevens, yeah, over there in the back, if you don't mind moving over to here. Okay.
Okay. First of all, let me just say quickly, I will really enjoy telling George Rutherglen had a nice comment about him. Know him at
You need a
UVA.
mic.
I'm sorry. I'll enjoy telling George Rutherglen about your nice comment about him. So that was terrific. Such a good guy. You mentioned George Rutherglen as your clerk. But I wanted to ask the other side of the coin about perceptions of the court, which is the rise of these kind of wonderful cultural presentations of judges. I'm thinking about here recently, there's been an interesting play about Justice Scalia called The Originalist at the Arena Stage. Of course, there had been something done about Justice Marshall. And I gather there's also an opera coming about Justices Ginsburg and Scalia. I guess I'm curious about how you think about the sort of notion of the growth of cultural presentations of justices.
So the question is, there's been a mass, I just wrote about this today, so thank you, but there's been a mass of new cultural presentations of the justices, a play about Justice Scalia, an opera about Justices Scalia and Ginsburg. There's going to be a movie about Justice Ginsburg. There's a movie about Clarence Thomas. What do these large cultural statements about individual sitting justices signify? I think, is that the gist of the question?
Well, they apparently signified that those particular justices are very interesting people, and they are. They're both exceptional people. It reminds me another. This isn't perhaps responsive, but I saw the movie recently about the painting in the artist in Austria. Yeah. And a friend of mine had said to me before, I should see that movie because you're in it. And I went to and the person she thought was Justice Stevens was Bill Rehnquist. And I'm glad it was, because the guy who played the part was very unattractive.
Oh, good. Okay, there's a question here. Oh, do you mind, I'm sorry, identifying yourself as a speaker? Just say who you are and then ask your question. Thanks.
Sure. My name is Marcy Cohen, and my question is, can you comment on what is going on in the Senate by keeping federal judges hostage because of political payback to the Obama administration?
I didn't hear it.
Do you want to do that?
Sure. The question from Marcy is, what do you think is going on in the Senate with senators keeping federal judges hostage as basically payback to President Obama?
Well, that certainly should not happen. I don't know whether in fact it is happening, but certainly I do not approve of that practice. But I don't know enough about what's going on now to really comment on whatever gave rise to the question.
A question here in the front, yeah.
Good afternoon. My name is Paul Waters. I just graduated from GW Law last year, and now I'm working at a foundation. But my question to you was about legal education generally, and what do you think of our current legal education system, sort of given lots of articles about how it might change to better help graduates get jobs or learn more about law, or just have more lawyers come through the system?
So the question is about legal education and the so-called crisis in legal education that we've been reading about the last few years, and what we could do to change legal education to better prepare law students for law jobs, to get them law jobs, and is there a way that we could do law school better? I think that's the gist of it? Okay.
Well, my impression of the law schools I visited during recent years is pretty favorable. I must say that even schools that are not thought of as Harvard or Yale or the very, very top school are better members of the faculty than I had anticipated on several visits to schools. And I think in general, the quality of the faculty members of the law schools is really much higher and much better than is generally appreciated. I think there are a lot of very good law schools and a lot of good academics out there, and So I'm not sure how that responds to the question exactly, but I generally keep trying to do the best you can.
Yeah. Right here, yeah.
Hi, Stephen Spitz, a fellow Chicagoan. I have a question that's sort of the subtext of your book, and that is there are a lot of people who think that you really can't amend the Constitution these days because it's just too difficult and it's really something that's historical but can't be done. Can you speak to the issue of why constitutional reform is, as a general rule, something that actually ought to be discussed?
So the question is that there are a lot of people who think that amending the Constitution is very difficult, too difficult to even undertake. And he was wondering your thought on reflecting on. Say that again. I was trying to. I'm sorry.
Yes. Well, what would you say, Justice Stevens, to people who say that it's really next to impossible to amend the Constitution as to why we should consider amending the Constitution?
So why should we consider amending the Constitution?
Well, it's a very good question, and my book has been reviewed and criticized for being unrealistic in thinking that it's possible to get 6 amendments adopted within any period of time. And that may well be true, but I do think even if a particular amendment is not adopted, I think putting it before the country as a whole and increasing attention to the issue and debating it on the merits of the issue may actually help change the law, even if the amendment should not be adopted. And I do think that it's not impossible to amend. It's difficult, and it should be difficult. And one of the critics of my book was I was thinking it was too easy, and it should be difficult. But I do think that a debate on a proposed amendment, such as an amendment that would change the holding of Citizens United, it has to be healthy because it has to increase public understanding of the issue and the likelihood that it will be changed. And some of the changes could be made by legislation that takes advantage of the gaps in the constitutional law now, and some of it could be done more narrowly. But I think I don't think that it is wrong to try to amend the Constitution when you think there is very serious holes in the law that could be changed. I mean, for example, I know that people reading the chapter in my book about sovereign immunity think, well, you don't need to amend the Constitution. But if you think about the issue and even consider amending it, you may actually improve the law, improve it by improving debate and public understanding of an issue.
In the second row here, yes, in the black and white shirt. Here, microphone's coming to you.
Thank you. Hi, Justice Stevens. Very, very nice to hear you speak. My name is Dania Korkor, and I work at Fair Vote, a nonprofit that works on electoral reform. And I was wondering what you think about structural electoral reform. There's so many different things. I know that you care about gerrymandering a lot. I know you're from a state that uses cumulative voting. So what of all these issues of adding a right to vote to the Constitution, of using a national popular vote to elect the president and ranked choice voting, multi-member districts, so many different big structural changes we could make to our voting systems, what do you think is the most important one, and what should we be really pushing for?
So the question is, in the world of electoral reform and making voting easier and better, there's a sort of menu of things that people suggest, national popular vote, enshrining the right to vote in the Constitution. What in the array of things that would improve voting is something that you think is important and doable?
Well, I think that having money play a lesser role in the entire process would be helpful. And I do think some of that can be done by legislation, state legislation and federal legislation, both of them. For example, states might raise the questions about financing by their own residents for electing people in other elections where they don't have the right to vote. It seems to me that the right to contribute to campaigns and the rest should have some connection with geography. The framers thought, in fact, our whole Constitution is structured on the assumption that geographical boundaries would make a difference. And I think they should, and I think some legislation in that area could have a beneficial effect. I think they could get rid of this vast difference between the constitutional issue and the political issue. I think they could get rid of excessive photo IDs, for example. It never made any sense as a big, and that has, I think, does have an impact on the process.
Right here in front. Yep. Microphone coming to you.
Good afternoon, Justice Stevens. I've had the pleasure of meeting your successor, Justice Kagan, and at a group that she spoke to us at, she told us one of her fondest memories on the court, outside of the court while being on the court, was her hunting trips that she does with Justice Scalia. I'm wondering what your fondest memory outside of the Supreme Court chambers is.
He's wondering what your fondest memory outside of the Supreme Court chambers is, and he recounted the story of Justice Kagan talking about her hunting trips with Justice Scalia.
Well, my fondest memories of working with other justices in non-judicial capacities.
Yes.
Well, I think really I used to play golf quite frequently with Byron White. We got up very early in the morning. He was a great athlete. He really was a national hero. And also he was a national hero during World War II. But some of my fondest memories of that kind are with Byron. Mm-hmm. Is that an answer?
Yeah, I was hoping there'd be more. Like, you know, but that's a good answer.
Yeah, here in like the third row. Microphone coming to you. Remember to say who you are so that we can.
Okay, I'm Ursula Najic, right here from Northern Virginia. Thank you for being here, Justice. The social media seems to me to have kind of revolutionized the speed of change nationally, internationally, and given a tremendous voice to a new set of, shall we call them journalists, the people. Is this, am I being a little bit ambitious in thinking that this has been radical in the way we go about making decisions on all sorts of levels of power? And is this a good thing, or is this a scary thing? Or good scary, or bad scary?
Medium scary.
So the question is the advent of social media and incredible speed and the citizen journalist has changed the way we have national discourse, international discourse. And Ursula wants to know if the rise of this kind of bottom-up form of instant journalism, instant dialogue, is a good thing, a bad thing, a scary thing, or an aspirational, wonderful thing, if you have some sense of this instantaneous social media conversation.
Well, well, I have to confess, I'm not as sophisticated as one should be with
So you don't have a Twitter handle?
I don't have a Twitter.
Okay, just checking.
I can work with the computer, and all, but I'm really not. I'm not a good person to ask about that. But let me amend my answer to the last question by adding one other incident. Years ago, Justice Scalia and I used to sit side by side on the bench. And one day we had an argument, and there were two confession cases involving one, a defendant who didn't deny his confession, but he wouldn't sign it because it was in writing. Another one who said, I didn't do that, but I did this. He talked about something else. And we had two very unusual confession cases. And I remember Nino leaning over to me and saying, "This is our dumb defendant day." and Nino has a marvelous sense of humor,
Yes,
by the way, if you don't know that. I don't really know how to answer the question about the change in technology. In general, I think it's all for the good, because it seems to me it does increase public general access to knowledge and information, and that has to be a plus.
Okay, in the back with I just see a black arm. Is that attached to the sweater? Okay, there you go. I'm sorry. Okay, I just can't see.
I'm short. Amanda Harris Savanametti with Regan Associates. I have a question about the diversity on the bench. In your many decades on the bench, the composition of the judges changed dramatically. Has that changed the discourse behind closed doors amongst the judges on the issues? Thank you.
So the question is about diversity on the bench, and whether the diversity that's on the bench now has changed the discourse that's happening in chambers after arguments.
Well, I'm saying, what's the question?
The question is about diversity on the bench. Right now, there are several women on the bench. There's a Latina on the bench. There's an African American on the bench.
I was the last. What's the term?
Are you going to say WASP?
Well, see,
because I'm not going to tell you to say that.
Yeah, I was the last WASP.
The last WASP on the court.
And the court has become more diverse, both in terms of religion and in terms. Well, I don't know if it's more diverse now. It used to be mostly Protestant, but now it's either Catholic or Jewish. The two. But anyway, is it a good thing? I don't think the religious affiliations of members of the court have had any impact on any of their work throughout
Well, what about the ethnic affiliations of the justices on the court? Has that impacted discussion behind the scenes?
I don't think so. I don't know. I don't think they think about that at all. I think they think of their colleagues without thinking about whether one of them's a particular religion or a particular race or anything. It really is not up front on anybody's agenda, I don't think.
Would you say the same about gender, that it hasn't, that having women there on cases where gender is a big issue, has it made a difference, or when you're in conference it just goes away?
I don't think it has made a difference. I had never thought of a female lawyer as being any different from a male lawyer. And I think that's the way most of my colleagues feel, too. They're outsiders observe the difference, but I think in terms of your everyday working relationship, it's just a statistic. Yeah.
Okay, I think we have time for one more. The gentleman in the back.
Is that Barry?
Hello, Barry Karras.
Hi, Barry.
We have two very important cases coming up in June that are going to be decided, one on the affordable health care and the other one on gay marriage. While I would love you to comment on both and your thoughts on it, I will concentrate on gay marriage and whether you feel the country is ready for a change like this. Do the justices truly take into account the social fabric of the country that is turned towards the acceptance of gay marriage? And while you don't have a crystal ball, how do you feel it's going to be decided?
How do I think it'll be decided?
Well, the question is, with respect to the gay marriage case that is pending, do you think that the justices take into account the social change in the country around acceptance of marriage, and then certainly if you want to answer how it's going to be decided, people would like to know, but that's your call.
Well, I don't know how it's going to be decided. That's an easy one to answer, and I don't think a judge can totally ignore what's going on in the world about him or her, and so you can't really answer that. But you do have a duty to try and follow the law rather than the election returns, and so it's a very interesting question. And I just don't really know the answer.
Nan, do you want to? I think on behalf of Jonathan and I, we would just say that this has been a tremendous honor and privilege.
It's been great.
Well, it's been fun.
Yes, thank you. I hope you all Thanks to Jonathan and Dahlia and Justice Stevens. It was such a treat. We'll see you soon again. And thank you, the three of you. You were just marvelous.